How's it going, everyone? Chapter 6, Professional Liability, Medical Malpractice. Kind of complicated chapter from the perspective of some of the other things that we've covered, but very interesting. And then also, it's kind of nerve-wracking to think about, protecting yourself from lawsuits and other things. But, healthcare, we're taking care of people and things happen, mistakes happen at times. So you want to make sure, of course, that you're doing everything you can to have coverage. Kind of like you have health insurance coverage to take care of if you have an issue, or car insurance coverage, medical malpractice coverage is essential in the healthcare sphere. I'm not going to go over the learning objectives. You can take a look at that, but the material, of course, is going to outline what we need to learn. There's a lot of slides here, so I'll go a little fast in some areas. Again, I like to keep the lecture at the 15-minute mark, just so you can pause and rewatch and do the things you need in order to understand the material. But let's jump in. Professional negligence and medical malpractice. Malpractice, of course, is a professional misconduct or demonstration of an unreasonable lack of skill with the result of an injury, loss, or damage to the patient. So that's what malpractice means, the definition. And of course, there's a lot that goes into that. Negligence is unintentional. So malpractice is misconduct, and negligence is unintentional. It's an action that occurs when a person performs or fails to perform an action that a reasonable person, when they say reasonable person, they mean someone with the training. So like a cardiologist, in the cath lab doing a procedure. If someone was in there that didn't have the training that a cardiologist would, that wouldn't be considered negligence. Maybe the provider forgot to do something that they normally do. It wasn't on purpose. But in a reasonable situation, another cardiologist is what they're trying to say would have done in a similar situation. So that's just an example. So the torts of negligence, and remember what a tort is. Go back in your textbook if you don't. That's an important thing to remember, and I don't have time to go over that now. But the torts of negligence are malfeasance, misfeasance, and nonfeasance. So malfeasance, just reading the definition here, is performing a wrong or illegal act. Misfeasance is improperly performing or otherwise doing something that you wouldn't normally do for a lawful act. And then nonfeasance is a failure to perform a necessary action. So these all these happens in negligence, quite often. I don't really know which happens more than others, but I've heard more of nonfeasance in my career throughout healthcare, just forgetting to do something because you have 100 different things going on. You're a doctor or healthcare provider that's super busy, and you forget to, flush the line or something before you ran fluids. It could be a variety of different things. So nonfeasance I hear about quite often, but it's covered in the torts of negligence, and just make sure you know these three items. You don't have to. I'm not saying in this material to memorize them, but know when you read them, know what they stand for and how they affect, of course, torts and situations that providers might be in, or any healthcare employee for that matter. All right, some of the D's, 4 D's of negligence: duty and dereliction. These are important. They're going to be test questions. Of course, is a responsibility established by the physician-patient relationship, that contract that the physician and patient has together to deliver care. And the dereliction, of course, is negligence and the neglect of duty. And then the other 2 D's, direct or proximate cause, and then damages. So direct or proximate cause is continuous sequence of events unbroken by intervening, like, if you make a mistake, you're not intervening prior to the mistake happening, that produces injury. And then damages would be injuries caused by the defendant. So the defendant, of course, in this situation would be the healthcare provider. All right, make sure you know the 4 D's of negligence. All right, it's hard for me to pronounce this. Preponderance, there we go, of evidence. One side must demonstrate, of course, a greater weight of evidence than the other side in order to win the case. That's kind of common language when any instances like this happen in any kind of legal case. And I'm going to try to pronounce this Latin term here, but it means the thing that speaks for itself. So 3 conditions must be met in order to outline that. So in the regards of negligence, injury could have not occurred without a negligent act. So that's the one thing that has to be, of course, highlighted. Second would be the defendant had direct control over the cause of the injury. So, from that perspective, maybe the provider didn't have the equipment needed in order to, do their job. That would be one way. Negligence would not be the effect, or then you could say maybe the provider shouldn't have done the procedure to begin with, depending on, of course, if it's life and death. There's a lot of variety of things that goes into this, so I'm just going down a rabbit hole here, and I could go down 100 different rabbit holes, but the defendant has to have control over the injury. And then, of course, the patient did not and could not contribute to the injury. So the patient, maybe the provider said the patient needs to, I don't know, a variety to take this medicine such and such time of day, and they don't do it. Of course, there wouldn't be negligence on the provider's part because the patient didn't follow directions. That's an example of that. So damages, here's the types of damages that can be awarded. There's compensation, of course, and then punitive. So there's two types of damages in a negligence case. Punitive is probably the more confusing one. Compensation, of course, is going to be, of course, financial, right, usually. So a punitive would be monetary awarded by the court to the person harmed in a malicious and willful way, meant to punish the offender. Usually they both involve kind of a compensation, but when I think of punitive damages, it's more of a way to punish the offender. You're not going to, in a negligence case, you're not going to see a lot outside of compensation. It's usually compensation, but there also can be situations where the provider loses their license as well. So nominal damages are a slight or token payment awarded by the court, sometimes just to outline, hey, there was a mistake. Maybe it wasn't as bad as indicated by the case. Here's a token payment in order to move the case along and kind of knock it through the system. Fraud also happens, right? Fraud is a deliberate misrepresentation or concealment of facts that represent unlawful or unfair gain. It's happening a lot in healthcare nowadays. You hear about healthcare fraud in a variety of different fashions, both from a provider perspective and also from maybe an insurance or payer perspective. Fraud is out there. This is actually a great thing to write about from a legal research project perspective. Here's a great quote that's included. Medical assistants have been involved in several fraud cases in the medical office. None have been charged so far. I wasn't aware of that until I've read the textbook and looked at the PowerPoint here, but that's just a little fact that wasn't included. All right, the Office of Inspector General. Here it said, like on the news or something, OIG. So that means, of course, Office of Inspector General. They protect fraud from fraud, and usually just Medicare and Medicaid, kind of DHS, Department of Health and Human Services, or HHS service lines. So they of course, represent violations of statutes and immunity for charitable organizations. But the OIG, it protects from fraud, kind of across the board from a federal and state payer system. And when I say state, Medicaid's usually run by the state, but they get funding from the government, so that's why the OIG is involved. So how do you defend malpractice suits? You got to have affirmative defense, so denial, assumption of risk, contributory negligence, comparative negligence. There's a lot of things that play into that, and it allows the defendant to present evidence that the patient's condition was a result of other factors other than negligence. So maybe there was outlining circumstances that wasn't, of course, standard. Denial. Maybe the plaintiff proves the defendant did wrongful or negligent act. The denial is usually the most common defense because they say, no, I acted in a way that I should have. And the jury often is the ones that have to make the decision whether or not the provider or healthcare provider did something wrong in that case. Usually denial is the number one thing in regards to defense. I got to go a little bit quicker here because we got to get through these slides. And then assumption of risk. Assumption of risk prevents the plaintiff from recovering damages if the plaintiff voluntarily accepts risk associated with the activity. A lot of times this is a note that they sign, hey, maybe this is an experimental drug, or they sign a contract just to say, hey, there's no legal risk here. Sometimes that happens in certain situations, maybe in cancer care and in certain complex areas. Maybe it's life and death situation, and then the contract, of course, is enabled. And you talked about the Good Samaritan law that applies in this instance too. And then assumption of risk, of course, the signature should be from the patient, but sometimes that doesn't happen, like I said, and there's laws to protect providers, like when an emergency situation happens. We're not going to go over this slide. Of course, I think you know a little bit about negligence. We've talked at length about that. So be sure to take a look at these two slides when you get time. A borrowed servant clause is really interesting. Employers lend an employee to someone else, so employee remains servant of an employer, but the employer is not liable for negligence caused by the employee while in service of a temporary employer. So say I hired a physician for my practice, and they go and work on the side somewhere else. Respondeat superior would not play into that, because I'm not liable for the work they do somewhere else. So that's what applies here. So maybe they're covering in another ED, or maybe they're doing a surgical case somewhere else. There's a borrowed servant clause that protects the employer, the main employer, if they have multiple work outside of the employer's practice. So ignorance at times happens too. Unintentional wrongs. Healthcare professionals should understand what's right and wrong based on the law, and arguing that a negligent act is unintentional is not a defense. So I didn't mean to do it doesn't work in a court case. There is a statute of limitations with a lot of these different clauses, right, or a lot of these different lawsuits. So you can't, look back, depending on what the crime is. You can't look back in some negligence cases, 20, 50 years from now and try to get, of course, compensation for something that happened a long time ago. That's in place to protect people. And I think statute of limitations is really important. But depending on type of crime, right, or the type of case, I think that's important to note too. Murder, of course, there shouldn't be an extended statute of limitations for that. All right. So another Latin term I'm not going to try to butcher and pronounce, but it means the matter has been decided by judgment. Once the court decides, a plaintiff cannot bring new lawsuits. So it's like you can't have double jeopardy in that case. And then professional liability, civil liability cases happen, and make sure you read over that. Physicians, of course, can be sued for a variety of legal things. That's why malpractice insurance is so important. It's really common. And then there is a promise to cure considered under contract law. So, read over this as well, and make sure you understand some of the liability practices that physicians run into. And an employer can be also liable depending on whether or not they provide the correct tools and, go about the process in a way that is standard for employers and practices. Liability insurance it's critical, right? There's claims. Organizations have liability insurance, and they help cover claims based on what they, might see. And just like any other person, medical malpractice insurance for providers, there is also liability insurance for employers. And then malpractice insurance is something that all licensed and certified medical professionals should carry. And sometimes the employer has that for, of course, their employees as an added benefit. I'm not going to go over the alternative dispute resolution because there's a lot here, and that's not something that you're really going to see on a test question. And then there is liability of other healthcare professionals. These are just examples listed, and they can be complex, so there's a lot here. Tort reform is malpractice reform. 32 states have passed tort reform. I think a little bit more than that now, but they're, of course, trying to prevent, just unnecessary lawsuits happening, and it raises the cost of healthcare. So we went over this to say, there's a lot here, but one of the things I want you to highlight, all these different types of things that providers have to protect themselves, and I think lawsuits, provide a positive thing for protecting people, so they have, a way to hold people accountable, but it also increases the cost of care. All right, so that's why tort reform is happening in a lot of these states. If you need anything, of course, don't hesitate to reach out. I hope you enjoyed this chapter. Thanks so much.